SJC-12051, ENGIE Gas and LNG LLC v. Department of Public Utilities, and SJC-12052, Conservation Law Foundation v. Department of Public Utilities.
Takes a scorecard to tell who's who in this case, so. Mr. Uwer, you may begin.
If you wish, Your Honor, I can, before my time begins, I can say what the scorecard is, if it helps.
We've got it right here.
Okay.
We've got it right here. We have a scorecard, so go ahead.
Welcome back.
Thank you, Justice Botsford. Mr. Chief Justice, may it please the Court, Thaddeus Hewer on behalf of ENGIE Gas and LNG LLC in this proceeding. With me is Jesse Alderman. For the first time in 86 years, the Department of Public Utilities has construed Chapter 164, Section 94A, to allow for electric distribution companies, EDCs, to contract not only for electricity, but for gas capacity as well. The Department's final order contradicts the statutory language of 94A, the statute's history, as well as the 1997 Restructuring Act of the electric industry, which restricts the activities of electric distribution companies to electric distribution alone.
Well, you know, you say that, but no one, you say that the Restructuring Act prohibits it, but usually when that is said, somebody points us to precise language of the Restructuring Act and says, see, here is where it is prohibited. But I didn't find that in any of the briefs here. Is there language you're pointing us to in the Restructuring Act?
That prohibits electric distribution companies from engaging in fuel purchases of gas? I think we would point to the definition of a distribution company. In the Act itself, it defines distribution company as a company that distributes electricity or owns distribution assets. It's a company engaging in the distribution of electricity or owning or operating or controlling distribution facilities. Where the legislature established that definition, it also established definitions of transmission companies and of generation companies. A distribution company is neither one of those unless it otherwise can be. And in the Restructuring Act, it was very clear in the preamble, which was incorporated into the Act, that a generation company and a distribution and transmission company were to be kept separate, functional separation of those two entities. And here, the EDCs...
I'm sorry, a distribution company and a generation company are to be kept separate?
Correct, Your Honor.
So you're suggesting that by purchasing gas, the distribution company becomes a generation company?
We're suggesting that an electric distribution company should never be in the business of purchasing gas capacity, or anything related to an LDC.
And
Yes,
is
Your Honor.
that because, in terms of the Restructuring Act, is that because the purchasing of pipeline capacity is basically goes to supply planning for the, and that's really a generation company task?
That's correct, Your Honor. As a matter of fact, electric distribution companies were expressly removed from that requirement after the Restructuring Act by an order of the Department, which we cite in our reply, and I believe
That's
the
not
Attorney
part of the
General said.
statute, but that's an order of the Department?
It was based on the Restructuring Act, and the Department said, in looking at the Restructuring Act, we have determined that Chapter 164, Section 69I, which previously required the conglomerated generation, distribution, and transmission company, what electric utilities used to be, that required them to do gas planning for perhaps their plants.
So they're
fuel
not
planning.
required to do gas planning. That doesn't mean they can't do it.
The regulation that applied to them was repealed.
So this is basically an ultra vires issue.
Absolutely, Your Honor.
Do they have the authority to, does an electric company have the authority to purchase gas as a matter of investment?
We don't believe so, Your Honor. That would bring the statute...
Not for ratepayers, not to put into the rate base.
Correct, not to put into the rate base. Presumably, if a electric company wished to use its own funds to go off and do things and not put the charge into its ratepayers, that's a different case. But the case here is a request by, or an order of the Department that would authorize an electric distribution company to purchase gas capacity on the other side of the generation asset, and then charge the electric ratepayers for the purchase of gas capacity. And as we've pointed out, the statute allows gas companies to purchase gas. It allows electric companies to purchase electricity, but it certainly doesn't allow an electric distribution company to get into the gas capacity business.
All right, so let's say we have an electric generation company. So they could contract for gas supplies?
Certainly, and they do.
To run, right. And they could pass that on to consumers?
That would be part of the wholesale price. So here, FERC controls wholesale markets for electricity. The state does not. The state
What does that mean?
The
Yes or
state
no?
controls the retail market, which means from the distribution company to the consumer.
Right, which is really through the distribution company. That's where the state controls the rates.
Controls the rates through a distribution company, but the wholesale market for electricity is not within state control.
Right, so the question is, could a generation company, electric generating company, enter into the same kinds of contracts that are proposed here and get sort of reimbursed for the cost of those from the consumers?
No, Your Honor. Electric generation is no longer under the jurisdiction of the department in that respect.
But would FERC include, if I'm understanding you correctly, does FERC include in wholesale rates the cost of a 20-year contract to get gas pipeline capacity?
So this,
For a generation company? I'm not talking about the DPU, I'm talking about FERC.
a generation company will purchase its gas capacity, and if it's purchasing interstate gas capacity, that's a matter for FERC, not for the department.
Right, no, I understand that, but does FERC include that? I mean, does FERC set rates by which those companies can sell?
FERC either sets rates or it, as we've pointed out in the Nazarian case, which then became the Hughes case and appeal, it engages in its oversight role by looking at the integrity of the wholesale market. And what it's looking at is making sure that intrusions in the wholesale market are not made on the state side, on the retail, by the retail entity, which here is the distribution company, which is overseen by the Department of Public Utilities.
Counsel, I was with you until I got to page 20. And you say that it's the plain language of the statute. And I get to page 20, and the relevant statutory text is, no gas or electric company shall hereafter enter into a contract for the purchase of gas or electricity covering a period. I mean, I don't know how you get to where you are from this language of the statute. It's a very tortured reading, applying this principle of statutory interpretation that I confess I had never heard of. Redenda singulis?
That's right. I presume Your Honor is not suggesting that either a sua sponte or an ad hoc suggestion that a phrase, merely because in Latin, is per se inapplicable as a de facto matter.
No, not at all. I'm just saying that I don't know how you read this statute in the way that you argue in your brief. You have to deconstruct it to add things to other words to come out the way that you're coming out. And I don't understand it. So could you
Absolutely.
explain it to an idiot in 10 words or less?
Well, let me join the.
10 words or less.
Let me join with Justice Hines. Could you explain, I'm assuming that you're going to basically say that there's a plain language reading that you advocate, but there's also an alternative plain language reading.
Correct.
So if you have two alternatives and you look at them, then you want to go, you're basically, I think, saying you can't just look at it at the language of 94A, that you have to take into account legislative history and legislative intent.
I would disagree, Your Honor. So the first point to make is that the department's final order here is based solely on the plain language. This is not the
I know the
equivalent of-
department's is, but is yours.
Absolutely. But
You just have a different plain language reading, and there could be two so which one is right?
no, Your Honor. We've pointed out that there is, to step back, this is a situation in which, because the department has declared that there is a plain language, its interpretation is not entitled to deference. It becomes a pure matter of law for this court. Next, I would point to the fact that we do believe that looking at the canon of redenda suggests, and we call it a canon, it's dressed up with Latin words, it's a rule of grammar, that if two parts of the same sentence relate to two parts following, it's gas or electricity, and then gas or electricity. The gas relates to gas, Electricity relates to electricity. That's what the rule, the canon suggests. The issue here, we've pointed out, is that we don't look at legislative history. Legislative history is very specific, as we point out in our brief. It's the things, the kind of issues that are surround the legislation, legislative reports, committee reports, votes on the floor that weren't successful. That's not what we're looking at here. Here we have the actual language of the statute 94A as it was passed in 1926 and then 1930.
So when does your analysis of that end? Does it end at a certain year? Or are we to look at the entire history of 164?
We have to look at what 164-94A said.
Just of 94A and not of 164 as a whole?
Not at all. We look at the whole as well.
Then how come we don't look at 8A?
We do look at 8A.
And what does 8A say? It says something that is,
It allows
a gas company shall not be authorized to engage in the business of an electric company, and an electric company shall not be authorized to engage in the business of a gas company unless in either case the Department of Public Utilities, after notice and public hearing, shall certify to the State Secretary that the department deems the public convenience will be promoted thereby.
That's correct, Your Honor.
And you're saying, is there some issue that 8A has not been met here?
Yes, we don't believe that.
Articles of organization changed and everything, right?
We don't believe that there's any public utility in the Commonwealth that has applied for authority under 8A. It's not indicated in the record as such. We would suggest that even if they did, they would still need the department to approve that as in the public interest, so that certainly wouldn't be an issue for this case. None of those have happened. And
Hasn't happened, but it could happen.
It could happen, but the final issue is this, that if you applied as an electric company, for instance, to become a gas company, you would then be subject to the requirements of gas companies as a gas company. It doesn't allow you to become a conglomerate company that says we do both all at once. And the reason that matters is because it would not allow you as an electric company to say, we've organized as a gas company, we would like to purchase gas and charge the electric ratepayers for it. All it would allow you to do is to purchase gas and charge your gas ratepayers for it. Certainly you could engage in that provision, you can use that provision under 8A, which no company here has done, but it would not allow you to mix and match across type of utility and type of fuel supply.
Unless you read 94A as allowing that.
Correct, and of course we don't. We've pointed out that if you go back to Justice Lang's question, this court has repeatedly stated that we look at what the intention was of the drafters at the time. So we look at 1926 and 1930. And when we look at that, it's very clear that it started out as an electricity company buying electricity, and then they inserted gas and gas distributively in those two provisions of 94A. And at the same time, at the very same time, Section 22 prohibited electric companies from engaging in the business of gas companies. Outright prohibition. That was later, as Justice Lang has pointed out, changed, but at the time, when you read Chapter 94A, at the time of 1926 and 1930, the legislature knew that gas companies and electric companies were distinct, and that electric companies could never purchase gas. So to suggest that in reading 94A as it was put together at the time,
Electric companies back in the 1920s, they couldn't purchase gas to generate electricity?
there was no electric gas. You're now being a bit anachronistic, Your Honor. There was no gas-powered generation.
Right. So you're saying they couldn't have purchased, if there was, they couldn't have purchased gas to generate electricity?
That's correct. They
that
couldn't have
what just
purchased it
the
for any purpose. Section 22 of the Tercentenary Edition, which we cite, says that they are prohibited from engaging in making or selling gas, just outright. It's
Making
not
or
our.
selling, they're buying.
Who's buying?
The electric company would be buying gas to generate electricity. That's
No,
how
Your Honor.
Electricity is generated.
Let me point, if I may, Your Honor. The electric companies here would be purchasing gas capacity.
I understand that, but you're talking 1926.
Correct. Outright prohibition.
Right. They didn't, these weren't divided between generation companies and distribution companies back then, were they?
No, they were electric companies. The gas companies were distinct entities.
Exactly.
All right, thank you.
Thank you, Your Honor.
Chief Justice Gantz, may it please the court. David Ismay for Appellant Conservation Law Foundation. Your Honor, I'd like to pick up on a question that the Chief Justice posed, that looking at the code, looking at Section 94A, Your Honor proposed that on its face it doesn't appear to prohibit what the department is proposing in the final order. And I would argue that that turns...
Not sure I said that, but go ahead.
Well, that posture turns this court's inquiry on its head. The department is an agency that is of enumerated and limited powers. It does not have plenary authority, despite the repeated assertion of the amici and the department itself. This court has ruled on that very recently in the Massachusetts Electric case that the department pointed you to with respect to a position that CLF had previously taken. There, CLF, side by side with the department, argued to this court that there was sufficient penumbra of authority that the department had such that it could charge pollution costs to the then fully regulated monopoly electric companies with regard to their generation. And this court corrected both the department and CLF as an amici in that case and said, no, the department is a limited enumerated power executive agency, and there's no statutory authorization for the department to wrap in pollution costs, even if it thinks it's in the public need. So too here.
The department can take into account the cost of electricity to consumers.
Take it into account for what, Justice Cordy?
Well, can regulate around that subject. I mean, so they're not to be concerned with cost and supply at all?
Your Honor, they have a very limited authority after 1997, and that authority with respect to cost and rates is that they may regulate through Section 93 and Section 94 the rates and charges that the EDC, the distribution company, charges to the retail customers. It expressly cannot deal in wholesale generation costs. The legislature spoke clearly in 1997 when it fully removed the entire business of producing, manufacturing, and generating electricity. That entire business was removed from the department's authority expressly. And there, in the record, the Attorney General has made it very clear, as I think we all might have guessed, that purchasing fuel to combust in a power plant is the core business enterprise of a generating plant. It's 75% of those private businesses' operating costs. So in 1997, the legislature spoke clearly and said the risks of that business, the business of generation, the risks and costs would be borne by private companies on the market and no longer be borne by Massachusetts ratepayers.
Let me make sure I understand the practical consequence of your argument. And I know that there's a dispute in fact, but let's assume for the moment that DPU is correct, that the only way pragmatically in which the electric generating company can ensure that there will be low prices during peak times is to do precisely what they are doing, which is to incorporate pipeline assurances into the rate base, that is the only way that they can assure low prices. Is it your view that even if they are right about that, they still can't do it?
Yes, Your Honor. It's hard for me to make that concession.
I know that you don't agree that they're right,
yes,
but
under
put
no
that aside.
circumstances.
But your view is even if they are correct, even if the only way to assure low pricing is to do what they're doing, they still can't do it.
That's correct, Your Honor. There's no. The question before the court today is what portion of Chapter 64 affirmatively gives the limited agency with enumerated powers only, what affirmatively gives them the power to turn companies authorized by the legislature to own wires and substations and to deliver electricity over it from the generation companies run by ISO New England to the retail? What gives them the authority to turn them into interstate gas brokers? And
Well, I mean, you would argue, the argument would be, well, if you look at 94A, you could read it to say, no electric company shall enter into contract to purchase gas covering more than a year without approval of the department.
Yes, Your Honor, and I'd like to address that and come back to Justice Hines's question about the plain language. The plain language inquiry here is not an inquiry by the court as to the meaning of the word or the meaning of the words together, gas or electricity in isolation. Those words appear 174 times throughout the code. The double construction gas or electricity appears 24 other times throughout the code. The plain reading of this statute, which is a de novo matter for this court to review on its own without any discretion, is how has the legislature used that construction consistently without contradiction, as the DeFiore case and the Eaton case say is the law in this state? How has that been used consistently for the last century?
Do we stop at some point, at some date? I mean, is it, are we to construe 94A solely at the time of its adoption within the context of 164 at that time? Or do we look past 30?
Your Honor, I would argue that on the inquiry I just described, the court could stop and rule for appellants. If it looks throughout the code, as our brief stated, it will see that nowhere else in the code is there even a hint that gas companies can assume the responsibilities of electric companies, or that electric companies elsewhere in the code are allowed to, at their discretion, which is the argument of the department, decide to practice a certain point of the code that is authorized for gas companies. There's 24 of those constructions, and not a single one has ever been, in 100 years of superintendence, not a single one has ever been interpreted this way by the court, except now. Except now, when they think there's a need, they cite a market failure and want to do something about it. But the Rosenblum case, this court instructed, just because a law may at times work what looks like an injustice, that is not permission for the department or this court to rewrite the law, to grant powers that aren't enumerated in the court. So yes, Your Honor, I think just going, we don't have to go to legislative history, we don't have to go to intent, but there's two things we have to do. We have to look elsewhere in Chapter 164, and we have to understand that it is the chapter as amended by 1997 Restructuring Act. The Restructuring Act touched every portion of Chapter 164 and radically transformed the way that energy and electricity and gas would be regulated in this country, or excuse me, in this state. So it isn't a two-part inquiry. It isn't that the department gets to say, with blinders on, that I think this is what it means in Chapter 94A, and then I get to step aside and look, is that consistent with the Restructuring Act? This is the Restructuring Act. Chapter 164, Section 94A was amended by the legislature in 1997 as part of a major restructuring.
I'm sorry, not that particular statute. 94A itself was amended?
94A was amended, Your Honor. The last provision of 94A, it hasn't been wildly material here, but it allowed the department to exclude certain companies from the requirements of 94A.
Well, going back to your first argument, the Restructuring Act surely separated distribution companies from generating companies.
It absolutely did, Your Honor.
All right, and you're saying now a distribution company that buys products which it sells to a generating company breaches or crosses that line.
Your Honor, I'm saying more than that. In 1997, the legislature, for the first time ever, created the electric distribution company. This is not a heritage animal of regulatory existence.
By siphoning or dividing up those functions.
Yes,
right?
Justice Foster, exactly. Prior to 1997, it was all lumped together in the old-fashioned vertically integrated monopoly. From that, the legislature pulled pieces out and created things that had never existed before in this state. A generation company was, for the first time ever, defined as such, in the business of producing, manufacturing, or generating electricity.
And there was a whole lot of regulatory work to allow time and, I think, compensation for the separation, yes?
Yes, Your Honor, huge amount of separation. It is true that the decision to divest one's company of generation assets was left to the discretion of the generating company, of the vertically integrated monopolies. But as our brief makes clear, and the silence from the department and the EDC amici confirm, every single one of those companies took up the deal. They took the money, and when they did, they transformed into electric distribution companies whose only affirmative role in the Commonwealth is to own and operate distribution facilities and to provide distribution services.
Is it your view that the position of the department is premised on a view that the 1997 restructuring, the philosophy or the point behind it has failed? Insofar as leaving it to the market for generation hasn't worked, at least from their perspective.
I think that's what's motivating the department to act here. But interestingly, Your Honor, the legislature spoke clearly just a few years ago. In 2008, it addressed the very issue that motivated the department here. It said, in order to, quote, mitigate capacity and energy costs for all customers, the department is hereby given new authority to superintend energy efficiency plans for gas and electricity.
And where did it do that?
It did it in Chapter 25, Section 21, the chapter that describes the totality of the department's own affirmative authority. It gave it a way to deal with this. It may be the case that the DOER and the department think the market has failed, but the only entity in this Commonwealth that has plenary authority to adjust that is the general court, the legislature.
All right, thank you.
Thank you.
Mr. Schofield, you need to be very efficient in your 5 minutes.
I will do my best, Your Honor, and may it please the court.
Let me
The
knock
question-
you off your stride right at the very beginning. So you're representing the Attorney General?
Yes, Your Honor.
So you sort of sidestepped the issue of whether this is even appealable as a final order.
Yes, Your Honor.
And your view is?
Our view is that Providence and Worcester suggests that the order here is not a final order under 25.5. But
we
and
should
this is a
decide it.
very important but if the public interest was sufficient in Providence and Worcester to reach the merits anyway, then it has to be here too, where so much hangs in the balance. First, a federal agency is currently poised to make a decision that hinges on the existence of this DPU order. Second, participants in the electricity market in Massachusetts have to recalibrate their decisions now based on the order because of the risk that natural gas-fired power plants might be subsidized. That has to happen now.
Even though there has been no ruling approving any of these contracts?
That's exactly right, Your Honor. And ENGIE makes that clear in their brief and their reply at pages 8 through 9, I believe. And we agree with that point. The third is that because these gas pipelines cross state lines, the order has a regional impact. So if the court were to reach the merits based on the public interest exception, we would respectfully ask that it grounds that decision in the specific, important, and unique public interests at issue here, so as not to widen the door further to potential premature.
I've lost you there. I mean, I understand your view that final order or not, we need to decide it. I get that. But is it your view that we should decide this in the public interest or based on the authority of DPU to do this?
No, he just meant the public interest in having a decision.
Having a
Now,
decision.
Yes, Your Honor.
Okay.
The test that's set forth, that it's in Providence and Worcester, it's a DPU case where the court relied on that, but it dates back to Wellesley College, I
So
believe,
when
from
you
the
say that
1940s.
I take it it's FERC that's poised to do something, is that right?
Yes, Your Honor.
What is FERC poised to do?
For this scheme to work, and I do want to get to the Restructuring Act because there are some very important questions that I think we have something to offer on, but to make this plan work, the pipeline companies have to receive an exemption from the FERC rules so that they can release the capacity directly to the natural gas generators. And so the basis for that request is the existence of this order. But for the order, they can't make that request. The order goes away, the request goes away.
If you wish to make important points about the Restructuring Act, you better do it now.
Thank you, Your Honor.
I'm at fault here.
No,
Yeah,
no, you're
yeah.
not.
You know, the central purpose of the Restructuring Act was to separate generation services, not just power plants, services, from distribution and transmission services. To effectuate that central purpose, the legislature, for the first time, all of these definitions are new as of the Restructuring Act, drew clear lines between generation and distribution services and required those services to be separated from one another. The department is clearly, I think Chief Justice Gant or Justice Bonsford has clearly crossed those lines here by allowing electric distribution companies whose sole function is to distribute electricity, and that's found both in the definition that's set forth in Section 1 of 164 and also in Section 1, capital B, where it defines the role of an electric distribution company and states that the exclusive obligation of an electric distribution company is to get the electricity to its customers. They no longer have, and this is a critical point, they no longer have as they did before restructuring, a power planning obligation. They no longer have an obligation to ensure that the reliable amount of electricity gets to their customers. Their reliability obligation is to make sure their distribution facilities, the lines and the poles, are sufficient to get the electricity that's purchased on the wholesale market to the consumer. These carefully drawn lines were not a tiny detail in the act to be cast aside based on the department's own views of the proper policy. They, in fact, were the central means by which the act intended to achieve ratepayer savings. So by crossing those lines, for example, the department will re-expose ratepayers to the very risks that the legislature sought to protect them from when it broke these entities apart, and two, importantly, will thwart the full and fair competition in the generation market that the legislature demanded. The dubious possibility that this plan may result in rate savings for ratepayers.
Let's say it's not dubious.
Doesn't matter.
Okay, so it doesn't matter whether it's
Doesn't matter, because the legislature decided.
smartest plan ever.
Could be, doesn't matter. Doesn't matter,
And the
because the
competition-
legislature determined how ratepayer savings would be affected. And they decided that the way to affect those savings was by promoting or by demanding competition in the generation market. And keep in mind that fuel is generation. The definition of generation is converting one fuel energy source into electricity.
So the competition, it's not just between gas and electric, obviously, it's solar power, wind power, all of that.
Exactly, Your Honor, and by subsidizing gas-fired power plants, they are creating barriers to the introduction of these other types of possibly cleaner
which need
and
even
cheaper.
more subsidies.
Perhaps, Your Honor, but as we've stated in our brief, the legislature, when it has wanted to tinker with these, with the markets, it said so expressly. And
All right, thank you.
I see that my time is up.
Thank you.
May it please the court. Good afternoon. My name is Tom Heyman, and along with Frank Powell, I represent the Department of Public Utilities. And I'd like to start by way of 3 points as an overview. Number one, the court should dismiss the appeal because Chapter 25, Section 5 only permits an appeal from a final order that determines finally the rights of the parties to a proceeding.
But this order has lots of consequences, whether it's final or not.
I fully agree with what the Attorney General has articulated with regard to Providence and Worcester. The appeal is premature, and it ought to be dismissed, but this court has discretion to address the merits, notwithstanding the prematurity of the appeal.
Okay.
But the Providence and Worcester case was clear that when an agency announces that it has authority but has not yet exercised the authority, the appeal is premature and subject to dismissal, and that's exactly the circumstance here. The department has announced it has authority to review and approve long-term gas capacity contracts for the benefit of ratepayers, but it has not yet exercised that authority. So this is subject to dismissal. And similarly, with regard to standing, and I'll be brief and then get to the interpretation, but with regard to standing, no contract has been approved. So it is impossible for ENGIE or CLF or anyone else to demonstrate that they've been injured or that they will be injured. We don't have a contract that we can look at to examine the terms to figure out whether there's any injury or will be any injury, nor do we have the terms of any potential DPU order that might identify conditions or stipulations that must be followed. And so this is premature, and the appellants lack standing, and so it should be dismissed. Turning to the interpretation questions, and I'd like to start immediately with the questions from Justice Hines and Justice Lenk about the plain meaning of the statute. And ENGIE has argued that the plain meaning of this statute prohibits the department from doing what it's doing. And I ask that you examine the language very carefully. There is not a word in Section 94A that prohibits the Department of Public Utilities from doing anything.
Where about the idea that you need to have something affirmatively conferring authority?
I disagree with that, Your Honor. And the Mass Electric case, it's at 419 Mass, talks about the department's broad authority when it comes to rate making. And that broad authority certainly includes the right to examine the costs that go into the rates. And
Even
so
if it's against a whole lot of other laws, it can just say, we think it's the public interest, therefore it's okay? I mean, that's sort of what you're arguing. it seems like.
No, not so, Justice Botsford. When it comes to rate making and examining costs, this is protecting the ratepayers, the consumers of electricity who don't have an opportunity to bargain. So the role of DPU is to protect that interest. And they have broad authority within rate making and within examining costs that are used to build those rates. That's where the department has broad authority, and that's exactly where the department is exercising its broad
Okay,
authority.
so how far do you go with this? I mean, am I correct that if one were to do an equation as to what the cost of generation involves, you would say it's a function of the purchase of fuel, the purchase of pipeline capacity, and then the generation of electricity from that fuel? Is that a fair view of what generation costs are?
I believe so. The
Fuel, pipeline capacity, and then transforming that into electricity.
Well, yes, but we're talking here about the distribution companies, so it's also the costs of distributing it. So it's the distribution companies, and here's
But if you're right, why did the legislature enact Section 94A?
I'm not sure. Okay, the legislature enacted 94A to deal with a specific subset of costs that utilities would incur. And what they are long-term costs. And what the legislature identified is if there's going to be, if utility companies are going to enter into long-term contracts, defined now as over a year, that the stakes are higher for the ratepayers because those costs are going to be built into the rates, passed on to ratepayers. So 94A exists to give the department an opportunity to look at a long-term contract because the stakes are substantial. So before...
Would there not be authority for the department to look at contracts of less than a year?
There is that authority, Justice Lincoln. It's within Sections 93 and 94. So all of the costs that go in to what an electric distribution company charges to the residents of the Commonwealth are reviewed by the department and passed on.
Okay, so you're saying then that the cost that you of course are purchasing, you're purchasing the electricity to sell it, to distribute it.
The electric companies,
The EDCs are.
correct.
And so you're saying that the DPU has the authority then, if it were to turn out that they could reduce the overall cost of distribution of electricity, if they could buy natural gas cheaper, that they could say, well, now we can authorize them to purchase large quantities of natural gas and have the ratepayer pay for that too?
If it's what the electric distribution company is purchasing, yes, that's fully within the DPU's
So
regulatory power.
And if it would turn out to be cheaper, if they could purchase the generation equipment, they could basically do everything involved in generation as long as it can be demonstrated that it will reduce the overall cost to the ratepayer.
Not there, Justice Gantz, because generation, of course, was carved out as a result of the Restructuring Act.
But isn't this reattaching it? That's sort of the
It is
central
not.
issue.
It is not, Justice Cordy, because in the Restructuring Act, electricity generation is defined. It's transforming one form of energy into electricity. That's what generation means. That's out of the regulatory scheme.
Doesn't this work? If you're right, the contracts for the gas line capacity are signed. Companies build the pipelines, and you've got to then, somebody's got to go to FERC and get some exemption from something else. So it's the most indirect way back to the electric rates that, I mean, it seems like it's really going to FERC.
The pipelines are not going to be constructed without FERC
Aren't you going to be
approval, but-
selling either to, if you can get the exemption, selling to designated companies or buying from, you're selling your capacity to somebody, right?
Correct. The EDCs will be selling capacity to electricity generators and potentially others. And the purpose of that, of course, is because we have capacity constraints that are making our electricity costs high. And so the DPU wants to add a resource to the market that is not generating electricity. It's not affecting the competitive environment for generation. EDCs are not generating, they're not entering that competitive market, they're not changing the players in that competitive market at all. They're adding a resource to the market that's outside of generation.
And so there's a 20-year obligation now on the electric ratepayers.
Well, we don't have a contract, understanding we don't yet have a contract that we're looking at, but at some point that's going to be subject to examination, and the DPU is going to take a look at that contract and determine whether it creates net benefits for ratepayers in the Commonwealth. Is this a good thing for the residents of the Commonwealth? And that's what the DPU is going to work on.
And the
Well, let's say
DPU,
that-
I'm sorry, go ahead. And the DPU could go further and say, it turns out to be a good deal if we can purchase large quantities of natural gas, and we will contract for 20-year agreements to purchase natural gas, and whatever excess we have, we'll sell that too. That's fair game?
That's fair game. To round out the question on plain language, ENGIE says that 94A is a prohibition, but 94A is a requirement by these utility companies to come to the DPU with a long-term contract if they want to purchase gas or electricity. It doesn't prohibit the department from doing anything.
I take it there's no way, just the way the business works, gas companies don't buy electricity, do they?
I think they do, and as a matter of fact, historically, there was affirmative language in the statutory scheme, and it's identified in our brief contemplating the ability of gas companies to purchase electricity. And with regard to the historical issue, and there's information in the commission report, as well as in census information identified by the Attorney General's office, sometime between 1927 and 1932, gas was being used to purchase electricity. And 1930, of course, was the amendment.
Produce
Right,
electricity.
to generate.
To produce, to generate, sorry, I misspoke. To generate electricity. And that's right in the heart of when the statute was amended. And I'd ask the court to look very carefully at the commission report and the language that they used.
What, in 1930?
In 1930, when they, and it's page 52, I think, of our addendum. It's been characterized by the appellants as authorizing gas companies to purchase gas. That's what they say was the change being made in 94A. That's not what the words are that the commission used. What the words are that the commission used were these, that 94A should be amended to include all purchases of gas and all purchases of gas and electricity covering more than a year. And that's exactly what the legislature did.
Let me ask you this. So there's a market problem. Let's assume that DPU and those who have done the studies are correct, that at the moment we need more natural gas available to ensure a reliable source of cost-effective electricity. Why aren't the generating companies then entering into these contracts?
Largely a factual issue, but if I were to hazard a guess, they are.
Because this would be perfectly fine, because they buy the gas.
True.
So it'd be perfectly fine for them to enter into 20-year contracts that would finance a pipeline.
I agree. And I don't know, as a matter of fact, why they haven't decided to do that.
Because it's too risky.
Well, what I do understand is that electric companies, electric distribution companies want this as a pass-through, and it's the service of the electric distribution companies. They care about their customers. They care about the energy supply in the Commonwealth, as does DPU, of course, and they care about the rates that the ratepayers pay. And so the only reason we're engaged in this exercise, yes, Justice Spotsford, the companies want to reduce risk, and the ratepayers can help reduce that risk. And the calculus that takes place by the DPU outside of 1537, the order of this case, but in the subsequent cases, is this an appropriate mechanism that will help ensure a necessary energy supply with minimum impact on the environment and at least or the lowest possible cost to ratepayers? So it's premature to choke this idea at this stage before the DPU has an opportunity to look at the terms of a contract and see if it can satisfy the goals of the Commonwealth in terms of energy supply and least cost.
But the argument is that the legislature in 1997 choked it off by saying we're going to have electricity generating companies and electricity distribution companies, and the twain shall not meet. Each does what they do, and that you are now involved, having a distribution company involved in what is innately a generation function, which is the purchase of pipeline capacity, and you say could go even further and be involved in the purchase of natural gas.
Again, generation is defined, and the purchase of pipeline capacity does not meet the legislature's definition of generation. There is nothing.
Right now, who is purchasing all the pipeline capacity? Generating companies.
Generating companies and yes, LDCs, certainly.
What's LDC?
The distributors of natural gas, so the gas that's used to heat our home. The people who...
So would the legislature not have understood that the purchase of natural gas and the purchase of pipeline capacity is a generation function and not a distribution function?
If they did, they didn't define anything in the Restructuring Act that way. There's nothing in the Restructuring Act that sought to diminish the department's power to deal with the distribution companies, which is happening here. And there's certainly nothing in the Restructuring Act that seeks to remove from the department the ability to add a resource to the market outside of the legislature's definition of generation, so as to help Massachusetts ratepayers. That's not what the Restructuring Act sought to do.
So you say that the department hasn't really done anything yet until it approves a contract. So in the meantime, what's the cost to the ratepayer and to everybody else who's involved here waiting to see if the department does something that everybody thinks, well, at least some people think it doesn't have the right to do? I mean, isn't there a cost to the other interested parties here? Is there a cost to ratepayers who will be reimbursing companies for developing proposals that might fit within whatever final order the department makes?
I'm not sure I see the ratepayers are paying for their electricity, and the hope.
But they don't, ratepayers are not charged with development costs. You know, the money that the electric companies and the gas companies spend developing resources, developing opportunities to generate or distribute, or whatever the case might be, isn't that a cost that the ratepayers absorb ultimately? Or is that totally something that the company does because they think it's the right thing to do?
I'm afraid, Justice Hines, I don't know the answer to that question. I understand the question, and I don't think there's evidence in the record. I do know that the 93, 94, and 94A are there to give the department an opportunity to review the costs and make sure that the rates based on the cost are fair. I don't know every single element of those costs that goes into those reviews.
Yeah, I'm just trying to figure out, you know, if this is, if the department can do this without consequence. In other words, the department can just sort of say, we haven't done it yet, but we might do it. Is there a consequence to to all of the stakeholders. If that's the position that they take, and if that's the position that the court takes, they haven't done anything yet, so we're not going to step in.
The only consequence that I see is that ENGIE and CLF are participating in the proceedings where the DPU is going to review the proposed contracts. But this issue comes up in the context of standing and whether the appellants have demonstrated harm, and they haven't cited any case to suggest standing based on the expense and effort they're going to incur to participate in those pending EDC dockets.
But on your theory, the next round, where the DPU considers the contracts, is going to have the EDCs involved in spending a lot of money and time trying to persuade the DPU that these contracts make sense. So will the costs from that then be charged to the rate makers, even if at a later point we were to determine the DPU didn't have the authority to do this in the first place?
Again, I'm not positive of exactly
Who
which.
else would pay for it other than the rate payers?
Well, it may not be qualified as a.
Yes,
I mean,
exactly.
The department can review what goes into the rates and say, this is not a qualified expense, presumably.
Exactly, Justice
they
Cordy.
would,
And
so
so
that's
that's the point, is that whether it meets the qualification or not, I'm not sure, but what I do know is that that would be the same as every rate case. So every 5 years, the distribution companies come before the DPU, and there's effort and expense involved in.
But the underlying premise is not whether or not the DPU has the authority to do it in those instances. And that's what's at question now. So do we decide it now, or do we decide it then?
The DPU urges the court to follow the lead of Providence and well, that the
Not that one.
Part one.
We have no
follow
choice
the
in
lead
that
of
one.
part one.
Providence and Worcester, Part 1. We fully recognize that the court's going to make its decision about whether to address the merits or not. And if it does, one thing we've not yet talked about with regard to statutory interpretation, obviously we think that the plain meaning is neither kind of company can purchase either type of commodity. That's the equivalent of the words in 94A, and it's plain on its face. The court need not go further. If the court does go further, it shouldn't go to the redenda doctrine, the small lobster case with a statute that says possession is prima facie evidence of the crime of.
Rules of grammar?
Absolutely, absolutely. But the rules of grammar lead to what I just said. No gas or electric company shall purchase gas or electricity equals neither type of company shall purchase either type of commodity.
I think it's fair to say that it can be read both ways.
There's a case on that, Justice Lank, and there's substantial deference accorded to an agency. If you find an ambiguity that the statute can be read both ways, then the appellants bear the burden of demonstrating that the department's interpretation is arbitrary, capricious, or whimsical. There's no way they can meet that burden.
Well, I think, isn't it fair to say that that's when, when you're doing that, you're not divorcing yourself from legislative history and looking at the rest of the chapter. So all the things that the Attorney General and ENGIE and the Conservation Law Foundation have focused on go into the court's calculus as well. They don't just write that out and say, well, it's ambiguous, therefore what the department says goes.
I agree. And if you find it can be read both ways, the things you ought to consider are not the redenda doctrine, but the principle of deference to the agency, how it fits within the legislative scheme and the legislature's purpose in enacting the statute, and the legislative history. And to follow up with regard to the deference to the agency, on the appellant's absolute best day, they can argue the statute can be read both ways. I don't agree with it, but on their best day, that's what they can argue. And in the Nantucket Sound case, this court said clearly the deference accorded to an agency's interpretation includes approving the agency's interpretation of a statute that can be read two ways. It's determinative. if that's how the court looks at the language in 94A.
The next sentence is always, but deference is not abdication. But
Agreed.
in any event, don't you have to win on two fronts here? Don't you have to win to say we have authorization under 94A, because that's what the legislature intended to allow DPU to do, that this is not merely a no one may, but a thou shalt permit, or that thou may permit, but also that even if it did say that in 1930, that it has not been undone by the Restructuring Act.
I agree. And it has not been undone because it doesn't meet the legislature's definition in the Restructuring Act of generation. We're not changing that competitive market. We're not transforming one form of energy. I'm talking about the electric distribution companies, not transforming one form of energy into electricity. It's adding a resource to the market that is outside of the legislature's definition of generation. And therefore, the legislature did not prohibit it in the Restructuring Act.
You say it's not changing the generation market. You are going to be reducing the cost of pipeline natural gas as compared to liquefied natural gas, correct?
Well, I think the aim, and I think it's a good aim, is to reduce the price of natural gas in Massachusetts tomorrow as compared to the price of natural gas in Massachusetts today.
Okay, but try my question. I mean, it does essentially subsidize the purchase of natural gas through a pipeline as opposed to the purchase of natural gas through liquefied natural gas or the purchase of other forms of energy.
It will have that effect because the price comes down, correct. And finally, with regard to those two other elements, the statutory scheme is necessary energy supply, least cost. And that's what the department is doing in trying to add capacity to the market to alleviate the capacity constraints that makes things less expensive. And as I said, the commission's study in 1930 that the Attorney General points to, that was not to limit any commodity that a utility could purchase, and it certainly was not to limit the department's authority in any regard at all. It was to expand the department's authority to help the department protect ratepayers, to look at these long-term contracts for commodities, because ultimately ratepayers pay for it. And so the department should have that opportunity to look at those contracts and see if it's the best interest of ratepayers. And for these reasons, the department asks that the court uphold its order in 1537.
Thank you.
Thank you very much, Counsel.